All rise. We will be. The International Criminal Court is now in session. Lord John to Court Panel International at 08. Please be seated. We will as well.
Yes, good morning to everyone. Could we call the case, please?
Good morning, Madam President. Good morning, Your Honors. This is the situation in Darfur, Sudan, in the case of the prosecutor versus Ali Muhammad Ali Abd-Al-Rahman, case reference ICC 0205-120, and for the record, we are in open session.
Yes, thank you very much. Appearances, please, then, for the prosecution.
Good morning, Madam President, Your Honours. Karim Khan, KC for the prosecution, Mr. Julian Nichols, assisted by Edward Jeremy, Alison Whitford, Diana Saba, Laura Morris, Rachel Mazzarella, Claire Sabatini, and Dihiru Santonta.
Yes, a pleasure to see you, Mr. Khan. Yes, defence, please.
Bonjour Madame la Présidente.
Good morning, Madam
Bonjour,
President, Your Honours.
Aux côtés de Monsieur Ali
The
Mohamed Ali
defense
Abd-Al-Rahman
team
ce matin dans
For
la
Mr.
salle.
Ali Mohammed
Nos
Ali Abd-Al-Rahman, who's
stagiaires,
in the
Madame
room,
Claire
is
Chauffard et
presented
Pénélope
represented by
Flores.
Claire
Les
Chauffard.
assistants juridiques
The
Eva
legal
Kalb,
officers
Nina
are Nina Ba,
Ahmad
Inyo,
Issa,
Ahmed Issa,
Anine Khali
Annie
et
Hali,
Marcela
and
Velarde.
Marcela Verade.
La conseillère juridique de la
The
défense,
legal
Madame
defense
Audrey
for
Matteo.
the
Mon confrère
defense is
Yann
Audrey
Edwards du
Mathieu
barreau
and
d'Angleterre
myself,
et du Pays de Galles, et
Cyril
moi-même, Cyril Lauchi, du barreau de
Lauchi,
Marseille.
and there's Ian Edwards, who's registered the Bar of Wales and England.
Also a pleasure to see you, Mr. Lighttree, after how many months is it since we all met? And you, Mr. Edwards. Yes, and the representatives of the victims, please.
Yes, good morning, Madam President, Your Honours, dear colleagues. Good morning to everyone in and around the courtroom. The participating victims are represented today by Associate Counsel Anan Shah to my right, Case Manager Saif Kassis behind me, and myself, Nathalie von Wistinghausen. Thank you.
Also, same for you, Ms. von Wistinghausen. Pleasure to see you. Yes, is there anything that needs to be said or done before the final addresses begin? No. Very well. In that case, we'll hear from the prosecution.
Madam President, Your Honours, this is obviously a very important day for justice, for the office, for the court, for victims, and not only the victims, the civil society that are in the gallery, but those that are watching or waiting for justice that they have yearned for almost 20 years. Your Honours, during the course of this trial, you've heard from numerous witnesses, you've had the opportunity to assess their demeanour and hear their accounts, and they have so eloquently and clearly underlined how deeply they crave justice, they want peace, and they want to return to their homes that they have left and sometimes they have moved from again and again. It's obvious that this chamber and the Rome Statute thank you, can't turn back the clock. We can't wish away the tragedy, the heartbreak, and the loss that so many have endured and continue to endure. And there's no way, there's no tool, there's no statute, there's no piece of paper, there's no normative value that can erase the layers of generational trauma that have been inflicted upon innocent women and children and men. And obviously, nor can this trial, nor can justice stop the ongoing conflict, which has reverberated continuously over the last 20 years. But what this process can do, what it is doing, and what we sincerely believe will occur, is tangible evidence that the rule of law means something. It is felt and vindicated by a fair trial, due process, by independent and impartial judges. And that quest, that craving for justice is not to be underestimated. And it's important to underline, Your Honours, what you have seen and what all the participants in the court have seen, that looking at the hemorrhage, the heartbreak, and consequences of the crimes alleged in 2003 and 2004 that were the subject of this trial, inflicted particularly on the Fur people of Darfur, they have to be uppermost in our thoughts and in this trial, because they have not sat down as spectators waiting for justice. They have clamoured for it, demanded it, and have been in every way, shape and form active participants in the investigation, in the proceedings, seeking your ruling after the trial is over. And so we reached this critically important day, the first trial concluding from the first ever referral by the Security Council of the United Nations to this court by dint of Resolution 1593, almost 20 years ago, on the 31st of March 2005. And Your Honours may recall that during my opening speech for the prosecution, the team put together a montage, a video showing a sample, a flavour of the types of crimes that were being committed in Darfur at the time the Security Council decided to refer the situation to this court. But one thing may have struck Your Honours. The testimony, the accounts that you've heard tested by the defence, paints a far more poignant and painful picture of criminality, heartbreak and determination by individuals that had the courage to speak up in these proceedings. And it's, we say, clear that overwhelmingly the evidence demonstrates that the conduct that has been alleged by the prosecution has been committed, and we've proved it, we submit, beyond reasonable doubt in relation to all of the charges, by the conduct of the accused in this case, Mr. Abd-Al-Rahman, also known as Mr. Ali Kushaib. And we say, Your Honours, not only have we established in relation to the charges the elements of the offence, but also importantly that at all material times the accused in this case was a senior Janjaweed member, a leader, and was actively involved in the commission of offences, willingly and enthusiastically. And that whilst the government of Sudan and others were arming the Janjaweed, ostensibly to deal with a rebellion, the stark reality is the targets in this case were not rebels, but civilians. They were targeted. they have suffered. They've lost their lives. They've been scarred physically and emotionally in myriad different ways. And 81 prosecution witnesses have been heard or presented to your honours by the prosecution. And they've detailed accounts of mass murder, torture, rape, targeting of civilians, burning and pillaging of entire villages, and displacement of millions of first civilians that to this day have not been able to return to the land that they feel such a connection with, their communities that their generations have lived on. And that includes the consequences that are experienced by so many, the children that were not there in 2003 and 2004. But they were born. They have been born in displacement camps, whether it's Kalmar or children that we saw, again, more recently displaced to Adre on the border of Darfur in Chad. And your honours have heard evidence of hundreds of fur males, community leaders, fathers, sons, brothers, subjected to torture, detention, and execution in Mukhjar and Alej, at the hands, we say, of the accused in this case, and their lives were very frequently summarily taken, executed callously, without respite, nor with any remorse at all. And that has left and continues to leave after tremors that affect families and the communities in the most profound manner. And your honours have also heard how rape was perpetrated by the Janjaweed militia, and indeed we've presented evidence that this was part of a policy by the Janjaweed and government of Sudan, a strategy against the fur population. And your honours have heard numerous types of evidence. I'm not going to give, with your leave, all the references because it can be provided later, but it's in the brief. But examples are the most humiliating types of rapes in front of family members, such as the account given by P1073, committed against children. Your honours will recall the powerful evidence of P11 and P1073, who was a child herself when she was raped by the Janjaweed. And you've heard evidence from numerous different witnesses, such as P1073, 1074, of physical harm, but also profound psychological harm. And the consequences that have been penetrate even deeper, that have caused even more difficulties because of the cultural situation of the individuals concerned. P11's testimony is worth, with your leave, recalling. And I'll quote what P11 said. Women who were raped, they are now disillusioned. I know some of them who committed suicide, they killed themselves. Some of them lost their minds due to this rape. They were living in isolation. They could not socialize with the others. And that extract of the transcript is found at transcript 91 at page 34. And P11 went on to speak about her own experience, stating, and again I quote, I could not complete my education because of the rape, because it was a stigma. I could not sit in the same classroom with my classmates. I was ashamed. The same transcript 91 at page 31. And witness after witness explained that survivors of rape very frequently had no access at all to medical care, such as P921, the effect of stigma because of cultural norms, that they didn't even feel able to have the support of their families by speaking about it, such as P15 or P1073. And those realities, those intersecting and overlapping conditions, realities for these witnesses, has further compounded the suffering that we say the accused is criminally responsible for. And your honours will never forget the accounts of children born of rape that has been presented to this court. P11 told the court, and again I quote, "People, when they pass by the road, they would finger point at a child who was born out of rape and would consider him the son of an Arab man, or would say, he's the son of an Arab man. Also, the women feel disappointment because they are left with a child of the enemy, the child that resulted from rape. Society looks disdainfully at such children, and on the road they would point at that child, considering him a child of rape." Transcript 91 at page 65, and P15 gives broadly similar evidence as to that witness's experience. And Your Honours would have seen, the world would have heard, the impact on a variety of actors. I think no part of the community, the old or the young, men or women, boys or girls, have been unaffected by the crimes of the accused in this case and their own lived experiences. But focusing on children, we see around the world and in this situation the sad reality that so often children are the silent victims of war. And so frequently their plight is lost in the broader narrative, conflated so frequently with the general civilian population. But we have heard, Your Honours have seen in the record numerous examples of the profound and enduring harm that's been inflicted, and P15 has described that. And I'll quote, if I may, P15's testimony. "Everyone was living in peace and security, and we didn't have any problem at all. Children were feeling safe. They were not scared of anything. They were going to school and they were playing and enjoying their life. There was no problems. And in 2003, when the war started, the children got severely affected. They never experienced such things before." That's transcript 93 at page 13. And that's really the juxtaposition of peace and war, of before and after and today. How lives were torn apart, not by accident, not by a tsunami of the weather or climate change, by deliberate decisions to ride roughshod over the rights of our fellow humanity. Those conscious decisions, those conscious, deliberate decisions of the accused in this case, we say demonstrate all the elements of the charges and give rise to the criminal responsibility we say has been proved before Your Honours. And it is clear that children were not just caught up in conflict, but were the targets of attacks. P15 described that children and the elderly were vulnerable. Children were detained in Mukhjar, for example. You'll recall, Your Honours, the testimony of P129, detained and killed not only in Mukhjar but also in Delage, the testimony of P907. And in the second wave of consequence of those crimes, how many children died of starvation? P15 recounted children dying on the road to Mukhjar, and that's detailed, for example, in the transcript 93 at page 14. Children who survived and who didn't die of starvation lived in the most miserable, the most appalling conditions that could be imagined. P1042 at transcript 28 recalls that witness P916 paints a hellish picture. A hellish picture. And that witness states, and I quote, when people came to Mukhjar, when they came, they were living in very harsh conditions, and children who were under 5 years old, many of them died. I can say that about 2 or 3 children died every day. Transcript 75, page 16. And those that managed to survive suffered a denial of education. P955, transcript 63 recalls that. Many were orphaned. And Your Honours, when the team and myself had the opportunity to visit Darfur and also see more recently in Chad, one sees this incessant consequences that is being triggered by the events that have been led in this trial before Your Honours. And the witnesses who've lost everything and the suffering that they endure today is an echo of what has been presented and has been subject to this particular trial. Your Honours, witnesses feel, the community feels they've been failed time and time again, because they have. This trial represents a moment of hope, where the world is not too busy or too distracted to look at other suffering and other crimes, but to focus on evidence, not polemics, to separate truth from fiction. And it's a remarkable trial for many reasons in my submission. I think, and I'm sure and I hope I speak for all parties, legal representatives of the victims and the defence as well as the prosecution, that with the excellent trial management of Your Honours, this has been a very efficiently run trial in difficult circumstances in the midst of a second wave of conflict. And in the course of this trial, Your Honours have heard from more than 100 witnesses. 1,800 items of evidence have been formally presented. 20 defence witnesses, 17 viva voce. The prosecution has led 81 witnesses, 56 have testified live, the evidence of 25 witnesses have been submitted in the record. Good cooperation in many areas with the defence, 134 facts agreed. And also, I'm proud of the team and the office for really sincerely assisting, offering assistance and supporting the defence in contacting, locating and facilitating the appearance of defence witnesses, as well as attempts to obtain documents for the defence from the government of Sudan. And this trial also is a first in terms of the first trial to present charges of persecution on gender, ethnic and political grounds, reflecting the reality, the intersecting nature of discrimination which detained males suffered, particularly in Mukhjar and Dalish. And it's also important for a wider purpose. As I alluded to at the outset, the first trial is drawing to an end, with the leave of Your Honours, from the first Security Council referral. And with all the criticism and perhaps dysfunction that we see all too often in the Council today, it harkens back to a better time in 2005, when the Council made this very important decision to refer the situation in Darfur to an international court, realizing that accountability and the rights of individuals was necessary to address a threat to international peace and security. A time when the rights of people were not automatically trumped by power or strategic rivalries. And Your Honours, it's only right to also thank those members of the Council that continue to support the court and the quest for justice. Your Honours, when I became prosecutor, I said I wanted to prioritise Security Council referrals. The team that has been so ably led by Mr. Julian Nichols, but all the team in the court and those outside and everybody in the courtroom. The work that is being done by this institution is an effort to show that these cases and the rights of Darfuris should not be forgotten, that cases should not be allowed to meander. And when I have said to the Security Council in my first briefing on Sudan that referrals should not be never-ending stories, today we are approaching, pending your final judgment, the end of the first chapter of a story which hopefully will vindicate the promise that has been made to victims. Your Honours, the meat of the submissions, as is apparent with what I've said, and the responses to the questions that Your Honours have given will be addressed by the members of my team. First, Mr. Julian Nichols will outline, with your leave, the overarching issues with the defence case, including the fairness of the trial. They'll respond to the defence assertions and case that the accused, Mr. Abd-Al-Rahman, was never known as Mr. Ali Kushaib. And then Mr. Jeremy will focus on defence arguments relating to the Janjaweed militia and Mr. Abd-Al-Rahman's leadership role in the counter-insurgency in the Wadi Salah and Mukhjar localities. And then he'll also cover defence arguments on jurisdiction and also then deal with defence submissions regarding Kudum and Bindizi. And he'll be followed by Ms. Morris, who will respond to the defence points again on Mukhjar and deal with some defence submissions or contentions regarding the crime of persecution that's alleged by the prosecution in this case. Ms. Alison Whitfield will then handle issues relating to Delage, the scope of the charges, and certain aspects of the Facebook evidence that is in the court record. And finally, Mr. Julian Nichols will close the submissions for the prosecution. Your Honour, at this particular moment, there's a lot of questions about the utility of international justice in a whirlwind that is the environment we inhabit. I sincerely do believe that this trial represents a step forward in the quest for justice, the demand for justice, and the beginning of really demonstrating, with all the difficulties that have been encountered by every participant in the courtroom, that justice can move forward in a way that is meaningful to the international community, to the Sudanese people, and to the Darfuri people that have been so awfully suffered the crimes we say have been proven by the prosecution in this case. With your leave, Madam President, Your Honours, Mr. Julian Nichols will take the floor. Thank you.
Yes, thank you, Mr. Khan. Mr. Nichols, just before you start, Mr. Nichols, if you're going to deal with some of the questions, which, as I know, as you know, we said you didn't have to, we could deal with them later. Could you indicate which question you're dealing with?
Yes, I will try to do that. What I intend to do, Your Honors, is just try to foresight that when I've tried to weave it in a bit, but I will give a little notice that I'm now dealing with a question.
Thank you. That'd be very helpful for us.
Could I ask that our slideshow be brought up? Good morning, Your Honors. Good morning to my friends. Good morning to everybody in the courtroom. I'll begin today where I did in my statement at the opening of this trial. I'll say it again. The militia leader who terrorized Wadi Salah, Mukhtar, in 2003 to 2004, Ali Kushaib, is in the courtroom with us today. He's sitting over there behind his counsel. I said we would prove it, and we have. The trial has proven beyond any reasonable doubt that the accused with us here today is the man responsible for the charged crimes committed in Kudum and Bindisi, Mukhtar, and Delage. What I'm going to do first, Your Honors, is discuss just some of the testimonial and documentary evidence that the accused is a person criminally responsible for the charged crimes. The evidence is overwhelming. On the slide in front of you, you see 16 prosecution witnesses who knew the accused, Abd-Al-Rahman, by both his legal name and Ali Kushayb. I won't read them all out. I did it earlier in practice, and it took too long. There's 16 of them. And there I'll refer you to, Your Honors, to Para 9, an annex of our brief in Annex 26. And these witnesses are not all the same. The prosecution interviewed and called witnesses before Your Honors who knew the accused personally and professionally, before, during, and after the charged crimes. These witnesses came from a wide range of backgrounds. And Your Honors, for confidentiality reasons, I'll show one. I'm trying to stay in open session for everything I say, but a couple slides I won't broadcast. So if we could go to the next slide, which should not be broadcast, please. And there you see, Your Honors, examples of the types of witnesses we called in this case that knew the accused. And just again, sorry, to be very careful, I won't read through all of these categories, but you see that it is from a wide range of backgrounds. I won't repeat what's in our brief. I'll refer you to Paras 9 to 27, and again, Annex 26, for examples of persons who were familiar with the accused and knew him quite well. But I will just touch on a few examples. P643 knew the accused in Garcilla for 5 years before the events and visited him in his undisputed pharmacy in Garcilla many times. P643 interacted with him in 2003 and 4, invited the accused to events, and knew him as a Musaid in the CRF after the charged events. P883 knew the accused since the late 1990s or early 2000s, long before these incidents, bought medicine from him, the accused, at his pharmacy in Garcilla. And again, knew him after the charged events when he was in the CRF in Riyadh Alberti and had trained in Al Ubaid, allegedly. And also knew about the assassination attempt in Yala that was discussed during the trial. P905 had known the accused since 2000, visited his pharmacy, would sometimes run into him multiple times a day, and knew some of his family. And P905 will probably be discussed quite a bit over the course of this closing, but he interacted with him, as the evidence shows. Again, knew of him as a Musaid in the CRF in Riyadh Alberti following the charged crimes. Finally, very quickly, P874 knew the accused since around 1991 or 1992 and would interact with him around once a month when he went to his business. This is laid out paragraph 16 to 19, Your Honors, what I've just gone through. Documents and documentary evidence also show that Abd-Al-Rahman is the person widely known as Ali Kushayb. Here, Your Honors, I will try to be addressing your questions 3, 5, and 6, at least in part. I'll run through some of this documentary now. Essentially, paragraphs 28 to 51 of our brief is where the focus is on these. Now, first, I'll remind Your Honors that the accused was known by his legal name and as Ali Kushayb by the government of Sudan when it investigated him for the 2004 crimes in Delege and elsewhere. And they began their investigation, you'll see, very shortly after the incidents in Delege, well before the issuance of the ICC, the first arrest warrant for Mr. Abd-Al-Rahman. The National Commission of Inquiry, or NCOI, as we call it, was created in 8 May 2004 to investigate violations in Darfur. So again, really quite soon after the mass killings, notorious mass killings in Delege. And its report was published in January 2005. As part of its investigations, the NCOI met with National Council members from the states of Darfur on 1st of June 2004. And in this meeting, a member from Garcilla stated that Lieutenant Ali Muhammad Ali, nicknamed Kushayb, liquidated 127 people outside of Delege. That's on the slide in front of you. The NCOI report further stated that on the basis of witness accounts, the leader of the Fursan armed militia, Muhammad Ali Kushayb, took detainees to the police area on Friday, 5 March 2004, and supervised them being killed and buried. I'll give the English ERN for that, Your Honors. It's DAR OTP 01160380. Now, as an aside, the defense claim that the NCOI, or at least I understand they claim, was part of a grand conspiracy that I'll talk more about later, to feed their client to the OTP, to deflect attention from, quote, quoting the defense of Para 52, perpetrators with senior positions within the government or army. In other words, the NCOI tried to fit up Mr. Abd-Al-Rahman to draw attention away from the real killers. It's worth noting that in the document provided to us, Kushayb appears once in this 166-page document on page 73. The prosecution has made submissions in our brief about the authenticity and reliability of the accused's interview with the GOS public prosecution from 2006. I'm not going to repeat all those arguments in full. It's at paragraphs 28 to 41 of our brief, and Mr. Jeremy, following me, will discuss some points of this interview. But here, I'm going to question 5. Which was about corroboration of the interview by a witness. Again, I'll speak carefully to stay in open session, so it may sound slightly oblique to your honors. The evidence of this witness, the one that your honors asked about, shows that in 2007, a request was received from the prosecutor's office in Sudan, the domestic prosecutor's office, not the ICC, to send somebody named Ali Kushayb from a relevant unit in Wadi Salah to Khartoum to be interrogated. The evidence of this witness is that it was reported back to the prosecutor's office in Khartoum that there was nobody by that name, Ali Kushayb. So the request was made again shortly after, and this time to send Ali Muhammad Ali Abd-Al-Rahman for interrogation by the Sudanese prosecution in Khartoum. And that's, I'll give you the reference, Your Honors. DAR D31, 50274, pages 4 to 6. This person testified as well, and essentially went through what I said, but the important point. I'll move a little quicker. The witness stated, and so it was first in 2007 that I heard that they, the government of Sudan, the Office of the Prosecutor, were referring to Ali Kushayb and Ali Muhammad Ali Abd-Al-Rahman as the same person. That's T151, page 20. That same Abd-Al-Rahman that was sent to be interviewed in Khartoum by the Office of the Prosecutor there was the accused in this courtroom. So is the interview reliable? Yes. This witness, answer to your question 5, confirms that before the interview takes place, the general prosecutor referred to the person they needed to meet to interview by both Ali Kushayb and his full name, Ali Muhammad Ali Abd-Al-Rahman. And you see on the slide before you just part of the interview itself, which confirms that. Just a couple quick points regarding this interview. Well, we know, in fact, from the witness I just talked about, as well as the documents, that the accused was interviewed under his full name and nickname by the prosecutor's office in Khartoum on 28 and 29 November 2006. P643 stated in his testimony that the man he knew as Ali Kushayb was in Khartoum under house arrest while serving in the CRF about this time. And finally, the witness referred to in question 5 said that he didn't remember the month that this happened, but he remembered it in 2007. I'll submit that's not a huge issue when the interview was in the end of November 2006. That many years later, the witness got the year slightly wrong. So, short answer to your question, provides great corroboration that the interview took place. Moving along, I'll just go through, Your Honors, some of the biographical details very quickly, uncontested. I believe all of them showing biographical details shared by Mr. Abd-Al-Rahman, the accused here, with the person that we can see from the interview. I won't go through all of them, Your Honors, but they are up in the slide in front of you. That comes out of the interview. I'll move on now. Further corroboration for this interview, and also the clear fact that the accused is a person known as Ali Kushayb, are meetings between the prosecution and the government of Sudan in Khartoum that occurred in January and February 2007, and defense may talk about these as well. Before these meetings took place, and there was a degree of cooperation at that early stage that was better, on 9 December 2006, I'll continue until I hear another bong. Now, before these meetings, on 9 December 2006, this is 10 days after the interview we've just discussed of the accused in Khartoum. Can I continue? Okay, again, on 9 December 2006, 10 days after the interview of the accused in Khartoum, the government of Sudan, Ministry of Justice, sent the OTP a letter listing suspects who had been arrested based on evidence of their involvement in the Delege and other crimes. Number 2 on that list was Ali Muhammad Ali Abd-Al-Rahman, also known as Ali Koshain at this point, Koshain. That's DAR OTP 0123 0002 at 0003. Following this letter, meetings were held in February 1st, 2007, and in that meeting, Government of Sudan representatives told the prosecution, correcting the nickname, that Ali Muhammad Ali Abd-Al-Rahman, also known as Ali Kushayb, had been arrested on 28 November 26, 2006, and interviewed while being held in custody. So very shortly after this interview in Khartoum, OTP visits Khartoum at that time, 2007, 13 years before we even see this interview. The GOS confirmed that they had, and we'll see why in a minute, but they confirmed that they had arrested the accused and interviewed him. And they gave the correct date even of the interview, which we know was from the 28th to the 29th of November 2006. After these meetings, the prosecution, or during these meetings, requested to interview the accused who'd been identified by the name Ali Muhammad Ali Abd-Al-Rahman and Ali Kushayb. On 31st January 2007, the government of Sudan sent us a letter, sent the OTP a letter, refusing our request to interview Ali Muhammad Ali Abd-Al-Rahman, also known as Ali Kushayb, based on complementarity. So we'll take a quick look at that letter. I think there's a pop-out, possibly. And here we see in this letter that interviews, not of suspects, but interviews with the National Investigation Commission went very well. We can all read what it says, and then it states that in particular they, the OTP, have requested to interview under Article 55 Hamdi Sharaf el-Din and Ali Muhammad Ali Abd-Al-Rahman, also known as Kushayb. Letter continues. Again, for time, I won't read through all of this. But the government invokes complementarity, stating, though the court has a general jurisdiction over the crimes alleged to have been committed in Darfur, however, it would actually assume such jurisdiction only in accordance with the principle of complementarity enshrined in the Rome Statute, and then goes on to say how they are investigating these crimes. So this is, again, Your Honors, strong evidence the interview is authentic. OT meets with the GOS in January, February 2007. The interview corroborates key details of the meetings corroborate key details of the interview that we don't have till much later. And I'll respond to some of the defense arguments later. But the constant theme, the man in the courtroom is a scapegoat from the GOS, suggests to Your Honors, it's a bit strange if the GOS is trying to set up Abd-Al-Rahman for all of their crimes, that one, they refuse to allow us to interview him. Two, they say we don't have jurisdiction to prosecute him based on complementarity. So the person being set up, they won't let us prosecute. And they refuse to surrender him for 13 years after the warrant comes out. Not a very effective frame job. Coming now, Your Honors, to question 3 that you posed to us. And this is about whether or not we tried to do more to authenticate that interview by finding and interviewing persons present during the interview of the accused. We did try. I don't think this came up I can't remember if this came up in any argument in the trial before, but we did investigatively. We had the file, the interview of the accused. There were names of certain people who were taking part in the interview from the government of Sudan side. We wanted to interview them, of course. We tried. We weren't able to do so. But what we did introduce in evidence and bring before your honors was a different form of authentication of that interview, which is two witnesses, P878 and P883, who had been interviewed as part of this very same inquiry, and were able to authenticate their interviews. Defense make the point that if you look at the interview that we received from the government of Sudan of their client, that it looks different from the interviews of witnesses, 878 and 883. First of all, I'll note that when they showed the interview to their own expert witness, D16, they didn't put any questions to him about those other interviews and seeing if they matched. They ignore that part of his testimony. But the point I would make is that you would expect these documents to look different in the sense that one is of a suspect interview. It's the equivalent of a 55-2 interview in the office of the prosecutor, a very formal setting compared to these other witness interviews. So you would expect it. It's not surprising that it looks different, since it's a completely different type of interview of a different person, in a different setting. I'll move on now to some more questions about documents, and this will go to question 6, Your Honors, that you posed to us. Again, trying to stay in open session the whole time. I'll refer to these documents as A, B, C, D, and E, as you did in your question, if that's all right, rather than in order to stay in open session. And you asked about the indicia of reliability for these documents. Starting first with documents A and B on your list. These date from before the arrest warrant was issued and deal with the accused. These are two documents provided by one witness, so they can be dealt with together. First of all, both documents A and B, provided by the same witness, the witness testified how they come from the same collection of documents, the same place of storage, and they both mention Ali Couchet. First, document A, again, I won't bring that up because it's confidential, but several details in that document match well what we know about the accused as Ali Couchet. He's described in document A as an Agid al-Ogada, commander of the Fursan, that he had a deputy named Bon Juice, and the defense concede in paragraph 791 of their brief that Bon Juice was Ali Couchet's deputy, that he joined the CRF around 2005. He had the rank of Musaid, warrant officer, and he was leader of the CRF in Riyad al-Berdi. Coming to document B, again, same type of document from the same place, from the same witness. I won't go through it in detail. You can find our discussion of that in paragraph 44, Your Honors. In this document, which is from 2006, so a couple years after the alleged incident, the last crime charged, again, the biographical details match. Ali Couchet is mentioned as the commander of the Al-Fursan, otherwise known as Janjaweed by some people. Again, mentioned with Bon Juice, who at this point he's having some difficulties with and tensions with. The reliability of these two documents can be discussed from question 6, A and B, can be discussed together because they came from the same source, P547. They've been authenticated by that witness in his testimony. And I'll point you especially to how the witness carefully described the chain of custody and the process, where the documents were stored, how he had access to where they were stored, how he physically obtained them, how he retained them and encrypted them, and then how he finally delivered them. And, Your Honors, that's at T50, CT3, page 13 to page 21.
Sorry, colleague. I'm informed that there is no interpretation in Arabic at the moment.
I'll stop for a moment then.
I have a sign that now it works.
Defense, of course, cross-examined the witness extensively on this point. We say failed to make any dent in the reliability of these documents. I point you to one exchange. P547 addressed this challenge and attack from the defense. And he stated very articulately that there was not a scintilla of evidence from the defense's cross-examination to show that the information he provided was untrue. And he was right. That's T51, CT2, page 73. He also testified and verified in his testimony and explained how he could see that there was no tampering with those documents before they came to your honors. And finally, he explained to your honors how it was really impossible, given the nature of the documents and where they were stored, that any of these documents could have been fabricated before he obtained them, because the purpose of these documents and where they put them meant that the information had to be correct and had to be authentic. He did, in answer to questions from your honors, actually say now he couldn't say that everything in every document was correct, but that those documents were authentic and reliable. And just to finish off on these two, our friends have provided no evidence whatsoever or credible argument to show that these documents were fabricated or tampered with in any way. Moving on to the document C in your question 6, Your Honors, and I hope it's okay if I refer to them that way. This one I can actually, I think, can show. This is a Ministry of Defense document. I don't need to be quite so careful with this one. It's from a different source than the first two I just described. And it shows that in 2005, again, after the charged crimes, the accused received weapons, pop out please, from the GOS in his full legal name, Ali Muhammad Ali Abd-Al-Rahman, 2 years before the warrant was issued. And we don't have the translation up here, but I'll note that the accused, Ali Muhammad Ali Abd-Al-Rahman, is listed at number 5 of this document as receiving vehicles and weapons from the Ministry of Defense. Number 1 on the list is Sheikh Musa Hilal. And the witness who provided this document, and it was introduced through towards your honors, explained how this document was found in a folder or file under the name Ali Kushay, the Ali Muhammad Ali Abd-Al-Rahman supply document under the file Ali Kushay. Very briefly, Your Honors, as with the previous documents I discussed from the other witness, comes from a credible witness. If you look at his profession and where he was at the time, it's clear he had a position to access and obtain these documents. He provided a detailed account of the database and how he had access to this document and what types of documents were contained in that database and why this one would be there. And the chain of custody, again, abundantly clear. And how he found this document in essentially a routine way. Again, I'll discuss it more later, but defense arguments, these are all forgeries in order to frame their client. It's a document from a year after any of the charged crimes, just saying that he released weapons. There's no evidence whatsoever of fabrication by the accused. I'll have to speed up a little bit, Your Honors. Documents D and E, which are about destroying Bendisi. I'll be really quick on these, Your Honors. I can discuss them together, because again, they're from the same source. They were hand-copied under the same circumstances. The witness explained that. We deal this in our final trial brief at paragraphs 49, 170, and 260. But just the points I'll make quickly, Your Honors. Of course, these are handwritten. It's a different story than the other ones we've gone through. But I'll make these points. The witness who explained, who introduced these documents and copied them was very close, which my friends ignore, to the official's office where he took them from. He was trusted by that official. He would have been allowed to wait in the office. That was routine. The defense make the argument it's impossible that anybody could just wander in and start looking at these documents. He wasn't just anyone. He was somebody very close who worked with that official, the office they came from. He had no other way to preserve this evidence other than to hand copy it, because he didn't have a cell phone with a camera on it. He couldn't take them to a copier. The only thing he could do to preserve and copy what he thought was important was to hand copy them the way he explained. These aren't huge, long documents. And the witness explained how it didn't take that long to copy them. He was able to do it quickly, fortunately, before he was seen. The defense argued that it would be illogical that he put all these details into the documents, including headers and things like that. But if you look at this witness's background, what he did, what he worked, they're trained to preserve detail and to make, he wanted to make as accurate a copy as possible. Finally, the witness was 4, and he had seen documents expressly directing the destruction of his people. It's not incredible that he would decide he wanted to preserve those.
Mr. Nichols, can I just say something very quickly? As I said, as we said in our clarification note, we appreciate that some of these questions require somewhat lengthy answers, and we don't want you to divert from what you actually want to say to answer our questions. We can deal with them later. So if you want to cut out...
All right, Your Honors, I may cut some points then.
Yeah.
Now dealing still though with the question 1. The videos. Come to the videos now. And you asked questions about those in question 1. There is no dispute that it is the accused, Mr. Abd-Al-Rahman, who's in the courtroom in all 3 of the videos. That is not contested at this point. For all of these, Your Honors, I'll rely on and try not to reiterate too much what's in paragraphs 9 to 11 and 62 of our brief, but I will make a couple more points. First, what we call the surrender video. Let's recall, the accused provided this video stating his full name and nickname through his contact, P869, to the OTP. In the video, I'm only going to play the first few seconds. He states, I am Ali Muhammad Ali Abd-Al-Rahman, and my nickname is Kushaib. Let's play the video, please.
الرحمن الرحيم أنا علي محمد علي.
There is no evidence of duress, coercion, anything regarding this video where he's sent to the office of the prosecutor stating truthfully that his nickname is Kushaib. There's no issue of source, there's no issue of chain of custody. The video should be given great weight, Your Honors, we say, as to the proof of the link between Abd-Al-Rahman and the nickname Ali Kushaib. We don't need this video to prove it, but it is a strong, clear piece of evidence which does prove that it is him. The defense, in their paragraph 187, state that Your Honors can infer, they haven't presented any evidence on it, that the accused had a burning desire to clear his name and surrender. You wonder why, if that's the case, he waited 13 years to do so, and until after his protector, President Bashir, was deposed. The defense also make the argument that the accused sent this video and surrendered because he was frightened, essentially, that the government of Sudan would arrest him, as they had President Bashir, Hussein, and Haroun, also on warrants. Well, I'll just make the point, Your Honors. If that was what was in the accused's mind when he sent that video to surrender, he should have testified about that. His lawyers can't testify for him. And the defense made a truly absurd argument, Your Honors, and I say with respect, that somehow the office of the prosecutor would not have accepted the accused, would not have accepted the surrender, and said, unless he said his nickname, Ali Kushaib. Why did he say plainly his full name and his nickname is Ali Kushaib? Your Honors, often the simplest answer is the correct one. He said it because it is his name. Now, the other two videos, Your Honors, we commonly refer to as the teacher video and the I'm sorry video. Many witnesses, including defense witnesses, recognize the accused in these two videos. Defense initially contested that it was their client in these two videos, put us to our proof, wouldn't say it was him, until their own witnesses confirmed that it was the accused in these videos. And paragraph 93, they note that they do not dispute this any longer. The teacher's video, Your Honor, for time, I'm not going to play it. Your Honors have seen it before. Defense witnesses D1, D5, D8 confirmed that it is the accused in this video. D8 was actually, well, I'll skip that for confidentiality reasons. This video, for everyone, the accused seen in this video, it's from around 2019-20, after the fall of President Omar al-Bashir. You can tell that from the context of the video. And the accused is addressing a crowd in Riyadh al-Burdi about a problem with the teacher in his capacity as a warrant officer in the CRF. The main point I want to just make here, in addition to the video showing how charismatic and what a good speaker and presence the accused has when he is acting as a leader there in Riyadh al-Burdi, is at the end of the video, which we have on the slide, a person in the crowd salutes the accused, praises the accused by shouting, "Long live Ali Kushaib." And we can take that down now. I will note the defense's explanation, Your Honor, for why somebody in the crowd, Riyadh al-Burdi, 2019 or 20, calls their client Ali Kushaib in a friendly, positive manner. This is defense final trial brief, paragraph 194. But naturally enough, as more people became aware of the court's interest in Mr. Abd-Al-Rahman, the more the community would have become aware of the association between him and the name by which the court invariably referred to him. Thus did he become increasingly, albeit involuntarily, linked to the nickname Ali Kushayb. That being the case, it is understandable that an excitable member of the crowd during the speech depicted in the teacher's video may have wanted to show his or her support of Mr. Abd-Al-Rahman's robust view of young persons who are disrespectful of or even assault teachers in the town, and to have wished long life to Mr. Abd-Al-Rahman using the name by which by that date he had become, against his will and as a result of the OTP's actions, closely associated. That is a pretty contorted argument, Your Honors. In order to show support for their client, who is not Ali Kushayb, a member of the crowd saluted him using the name of a notorious Janjaweed criminal wanted by the ICC for murder, rape, and other serious crimes. And the defense here appear to be saying that everyone in Rahat al-Berdi would have known in 2019, that the accused, the head of the CRF and a prominent person in their area, was known as by the nickname Ali Kushayb. Just to point out, that's an evolving defense throughout this trial. They took the opposite position in their opening. In their opening, my friends claimed that many witnesses never even heard the name Kushayb until the news surrounding his arrest. That wasn't working very well, so it changed mid-defense into everybody knew about him. But let me just take you to what they said in the opening. And this is regarding witness D32. It's T129, Your Honors, at page 23. But if Mr. Abd-Al-Rahman had been known by the nickname Ali Kushayb after 2004, D32 would know about it. He will testify that never once in the entire time that he knew Mr. Abd-Al-Rahman over many years, never once did he call Mr. Abd-Al-Rahman Ali Kushayb. Never once did he hear someone else call Mr. Abd-Al-Rahman Ali Kushayb. So he never heard somebody yell, "Long live Ali Kushayb," as we saw in the video. He too will say the only nickname he ever heard anyone calling Mr. Abd-Al-Rahman was Abu Nasser. Abu Nasser and nothing else. Here's the line, Your Honors. The first time D32, in common with many other witnesses, in fact heard the name Ali Kushayb, was in connection with the defendant in the context of his surrender to the custody of the court. So that was the theory. That was promised from D32 in the opening. He never even heard the name Ali Kushayb until the accused surrender. And I'll talk later about how, in fact, when he testified, D32 admitted he'd heard that name all the time since 2003. Finally, the Sorry video. I see it's already up. I'm going to try to speed up a bit, Your Honors, but again, in his CRF uniform, this video was filmed, we've learned from defense witnesses in Sorry, which was in the area of responsibility of the CRF for Rahat al-Berdi. And this speech is sometime between 2013. We don't know exactly when the accused is speaking here. Again, uncontested now that it is him, D1, D3, D5, D32, D39. All say the man we see in this video we're about to play is the defense's client, Mr. Abd-Al-Rahman. I'll play part of that video, which is it's about 1 minute and 40 seconds, Your Honors, from 4:06 to 5:47 of the video. If we could play that, please, Claire.
مسائل التامة برضو كل الناس دول يعني إذا في دول القبائل الأغياد إذا زوروا الشوفة مو يعني إحنا نرش بدنا فن الله ولا بعد باقي المشا والتاج الله هو ونقول ولا مو فوائد ما فهمت لأنه الحياة يعني خلاص انتهينا بعدين أنا بتكلم معاكم إنه المفروض قبل 20 سنة هسه عايشين في الزمن الفايت فايت عمري 75 كده ما لكن نقل من الحاجه الفاينل. كل الاقسام بتاع الناس الموجودين، كل الناس يا اخوان، انا وزنان انا كنت داير اجيل في ال 20000 دي جاني 17 عند 17 بس سلمت على يد قلت له هذا الناس مظلومين ظلم الحسن بن حسين، وهذا الناس مستلمين السودان لمده 16 سنه، وهذا الناس هم السودان، وهذا الناس صنعوا السودان. لكن حتى الان السلاح اللي بدأوا يسووه ده والذخيره هنا بقروشهم، والعربات بيدوا وكان العربات بيدوا شاتا ليل ما حقات الحكومه، حقاتكم انتم. الله اكبر. يعني شلنا منكم قروش، نشيل منه بقره، ونشيل منه شوال عيش، ونشيل من بين الدوشات كلها في كذا امريكي، في بيتين، في اي حاجه. وكان في مدفع هنا اذا ضربنا السوق ده الناس كلهم بموت، طلقه واحده والله كل الناس بتموت. بعدين ممنوع دوليا. بعدين اول حاجه محل بزعوني ده كلامهم صح، الناس دول ما كذابين. يعني تبقى الكلام اللي بتقوله ده صح، لانه انا كتبت ناس كده. اول حاجه
Abd-Al-Rahman heard here saying to a large group of people supporting him, 20 people filming him with their cell phones, talking about a tribal conflict. Hughes says, we'll spray them with blood. He talks about his direct link to President Omar al-Bashir, brags about it, and supplying President al-Bashir, which is kind of a strange thing for a humble retired pharmacist to say. He's also heard, Your Honors, bragging. What Radio Debanga says is true, because I've killed a great many people, and I'm still going to kill people. Here's what Radio Debanga had to say about Ali Shaib. One thing Radio Debanga says about him is that he's a militia leader, wanted by the criminal court. The accused says what Radio Debanga says about me is true. He's saying, I am a militia leader. I'm the person wanted by the ICC. He says that, surrounded by supporters who are filming him and chanting their support. In this Radio Debanga article, probably from around the same time, regarding the conflict with the Salamat, which the accused led and fought in, it states, again, what I've just said about them being the militia leader wanted by the criminal court. Ali Kushaib, who commands the Abu Tira forces, attacked the area and surrounding villages with 15 armored land cruisers, reinforced by military intelligence service troops under the Sudanese army. And he described the mobilization of Ali Kushaib of the Abu Tira forces, the CRF. The Radio Debanga articles are a clear reference to the head of the CRF, Ali Kushaib. When the accused says, what Radio Debanga says about me is true, he is saying, it's true, I'm Ali Kushaib. It doesn't make any sense otherwise that he's responding to that. So just to sum up, Your Honors, in the video he sent to the court via his contact, P869, very simply, introducing himself, the accused says, my nickname is Kushaib. In the teacher's video, he's saluted by the cheer, long live Ali Kushaib. In the Sorry video, he brags that he will kill more people, says what Radio Debanga about him, Ali Kushaib, is true. And in fact, it is true. He was speaking honestly there when he said what Radio Debanga says about me is true. Plain, simple, reasonable, sane examination of each video can only lead to the only rational conclusion. The accused here in the courtroom, who's in those videos, is Ali Kushaib. Let me very quickly now, Your Honors. Can I ask, are we going to 11, or are you going to go a little bit longer because we started a bit late?
We can. I mean, we'll have the break at some stage.
Okay.
But whenever suits you, Mr. Nichols.
All right, let me briefly address, I'm done with the videos in your question one. Briefly address, excuse me, a recurring misstatement that appears many times in the brief. Paragraph 60 is where the defense lays it out, and I think this is important as a way to look at how the defense are arguing their case. It's up on the slide. I won't read it all out because of the timing, but we see in the middle that the defense are talking about an exchange. They only put 2 lines of the transcript in. My friend, Mr. Lauchi, is my learned friend suggesting that the identity of the person indicted was not an important information? Mr. Nichols, me, no, it was not, because we knew that Mr. Abd-Al-Rahman was Ali Kushayb at that point, and that issue had not been raised. The language of paragraph 60, how do they characterize those 4 lines? He breached its obligations under Article 54(1)(a), such that there was a fatal blow to the fairness of the proceedings. The OTP never complied with its duty to investigate adequately or at all exculpatory evidence. The OTP conducted its whole investigation under the blinkered assumption that the accused was Ali Kushayb without ever asking itself the question of whether this really was one and the same person. There could be no better admission than what I said there. No better admission that the OTP never considered its duty to investigate exculpatory evidence. The OTP's investigation was 100% focused on collecting incriminating evidence, and we were blind to making the most basic inquiry into the identity of the suspects. And that the senior trial lawyer admitted to all of what I've just said, all of these terrible, unethical failings, in a surprisingly candid admission. And then they note, apparently trying to imply that you said us, the OTP, failing to do all these things was a good one, calling the admission a good one. That's a plain reading of paragraph 60. And this goes to Your Honor, which a point I'll make later, and you'll see from my colleagues. When the defense says something in their brief, you really, really have to check the cites. You really have to look at the transcript. You really have to look at the witness statement. You really have to look at the document, because sometimes, we'll have some examples later, they'll cite that a person was never in a room. You look at the transcript, the testimony is that they were in the room. This is an example of that, Your Honors. I'm sure we've made some mistakes, but this is truly extreme, what you see in the defense's brief. What was actually said in court that my friends did not include in their brief, this is at T102, page 15, lines 8 to page 15, 8. I think there's a problem with the site there. Anyway, it's T102, page 15, going on to the next page, I believe. This came about as I objected to the defense characterizing that in 2016 there was a gross problem with a witness not saying in a statement that he knew that Ali Kushayb, his name was Ali Muhammad Ali Abd-Al-Rahman. I made the point saying, we're talking about the statement of 2016. That was confirmed. I then responded to my friend. There was no important issue under that rubric, not a very good answer, at that time. And then we get to the exchange. Is my learned friend suggesting that the identity of the person indicted was not important information? My response, no, it was not, because we knew that Mr. Abd-Al-Rahman was Ali Kushaib at that point, and that issue had not been raised. And then Your Honors, Your Honor, in fact, when you say that it is a good one, state, I think the point that Mr. Nichols is making, Mr. Lauchi, which is a good one, is that until your client appeared, nobody knew was that he was going to deny being one and the same person. And, of course, in 2016, much of the evidence we've already discussed, not all of it, was known to us. We'd been investigating for all this time. The prosecution had already then ample evidence beyond reasonable doubt in our possession that Abd-Al-Rahman was the accused, had the nickname Ali Kushaib. And we never knew and couldn't have known that somebody was going to surrender under a warrant in his name and Ali Kushaib and then say he's not Ali Kushaib. We never would have thought in advance, of course anything's possible, that the defense would have gone along this line, which has, we say, proven to be quite farcical, in fact. And Your Honors, they appear to tarnish you by suggesting in the way this is written that the prosecution made some horrible admission of misconduct, never investigating exculpatory information, and you said, yeah, that's a good one. So it's just grossly misleading. I spent all that time on that because it appears throughout the brief, this admission which proves that the trial was unfair and has to stop.
Be a good place to break.
Yes, Your Honor. Thank you.
Right. We'll have a break until 11. I think we better say 11:35, so because of the delay. Yeah. Okay. Thank you.
All rise. We would be.